It is now 8:15. Welcome back. A federal judge has ruled that social media giant Meta must continue defending itself against claims that encouraged addictive use of their apps. The company, which owns Facebook and Instagram, is also being accused of failing to meet parental notice and consent requirements put in place by the Children's Online Privacy Protection Act.
Joining us now, once again, is our chief legal analyst, Khalif Rhodes. We know Facebook, Meta, I should say, they've been fighting lawsuits left and right over things just like this or similarly related. Their argument, I want to ask you what you think of, is that social media addiction is not an actual and established psychological condition, and so therefore they can't not protect against that. What do you make of that argument?
Going the scientific route is a good attempt. I mean, because if you don't have I say a lot here, if you don't have the facts, you pound something else. And you have the law, you pound the law. If you have the facts, you pound the facts. If you don't have anything, you just pound the table. And that's what they're doing right here. They're attempting to pound the table in a scenario that doesn't place them in the best situation. And I'll say for a couple of reasons. This case brought by California and attorneys general and a number of states alleges a couple things. That Meta built this business model on maximizing users' time in psychological manipulation. And they argue that its claims rooted in deception, unfairness, and violations of Federal Children's Online Protection Act. As you mentioned, that COPA is important for notice. So a couple of things. Meta was asking for a summary disposition. So before they made that argument that, they don't have a claim that can be stated, that's typically what you will argue. Person file or company files a complaint, individual files a response, but you also will file your motion to dismiss. Typically, they'll be rooted in something called a B-12 motion. Failure to state a claim where relief can be brought. That's what they're arguing. Because there's no official diagnosis, because it's not an official medically, designated thing, there can be no relief sought for this type of claim that they're bringing. The judge didn't buy that argument as well. On the other side, the states requested summary judgment for a number of their claims, specifically the COPA claim, and the judge granted it, saying, listen, there's nothing on the record that Meta is even attempting to fight or dispute that they failed to give notice to the parents. So this is a major win for the attorneys general and major loss for Meta for sure.
Do you think they're going to settle? I mean, this could be big time expensive. And then if you're Snapchat, some of these other ones, what are you out there watching, observing, going, ooh, we better make sure that we're not going to fall in the same line here?
They've been watching these complaints for a number of years. We got to look at this. This is a multi-district litigation. These MDL type of claims are brought by a number of states, and they will be tried as bellwether type of cases, trying to see how successful one can be before the floodgates open. And so you ask the question of, can this or should this settle? Most definitely it should, because once discovery is popped open, as it already has, these cases have been going on for a number of years, what you'll recognize is you'll either see that Meta has the defense, the receipts to pound the table, or they'll have the receipts to say, we'll settle. It looks like, in my estimation, that this one will ultimately settle at some point. Why? Because they're asking for these things to be remedied, because the attorney generals in these states, their goal is to protect their constituents. This isn't something that's brought by an individual that's seeking some large monetary gain. While there will be a dollar amount connected to it, the ultimate goal is put the processes in place to ensure that our residents that live in our individual states aren't negatively affected by something that we believe you guys can avoid. So this is the cheaper route than if it was to say an individual or a group of individuals bringing a claim on their own, and they would say, hey, I don't have to settle. We already have you dead to rights. We just want an unlimited check. And we've seen that in the past with these social media companies where there's $100 million settlements, not talking about $100 million jury awards.
When you talk about a settlement, obviously there would be a massive amount of money from this company, but a lot of times with these settlements, companies admit no wrongdoing, or, that's something that can be agreed upon. But is that really the route to go in the court of public opinion when you're saying, hey, you settled, I know you say you didn't do it, but I don't believe you?
Yeah, I mean, while everyone recognizes that you settle and you're going to make no admission of wrongdoing, the admission of wrongdoing in the court of public opinion is the fact that now you put things in place to prevent this from happening in the future. You've now created a process where you're not targeting and attacking and using and employing, as they say, psychological manipulative platform features to ensure that these students stay there forever, or I should say children stay there forever. Those are the types of things that will be a win in the court of public opinion if your child has been affected by this. If students that are being affected by this, if a group of kids are now, okay, we have something in place to prevent this future harm from happening, it's still a win. Even if they say, okay, we can admit that we didn't do anything wrong, the writing is on the wall because now you're doing things to prevent the very thing we said you did.
All right. Chief Legal Analyst Khalif Rhodes joining us once again. We'll see you again in our 9 o'clock hour.
Queen City News Plus. Just search Queen City News on your smart TV's app store.